Good morning, ma'am.
Good morning. I request roll number 38 to introduce our today's session's resource person, Dr. Shilpa Dongre, madam. Roll number 38.
Roll number 38
or 37. 37. Whose turn it is to introduce today's session?
I think 37.
There is no 37 numbers here.
As per the schedule, there is number 37.
Who is 37?
Roll number 37 already absent, ma'am. Already left the course.
38 is.
गौरव सर प्रेझेंट झाली का?
प्रेझेंट आज होणार नाही सर. आम्ही मॅन्युअल अटेंडन्स घेऊन टाकेल.
चालतं.
तुमच्या सेशनचीच अटेंडन्स होणार ते.
हो. Yes, any participant, please read the biota, ma'am.
Yes, anyone?
Please share the biodata again. I will read.
Okay, ma'am.
Okay, thank you. Biodata is there in the group. Dr. Shilpa Dongre, madam.
Ma'am, please forward the biodata once more so that I can read it. I am not able to find it.
Wait. I have shared. Wait, ma'am.
शेयर किया है मैम.
I just shared it in the group again. Roll number 1, have you seen it?
Yes. Give me a minute.
Okay, thank you.
Am I audible? Am I audible, everyone?
Yes, ma'am. Please continue.
Yes, ma'am.
A very good afternoon to everyone. I am very happy to introduce Dr. Shilparani Dongre, ma'am. She is an associate professor at B.N. Patil Law College, Chhatrapati Sambhaji Nagar. She has completed her BSc in computer science. She also has a degree of LLM, and she also qualified NET Law, GRF, PhD Law, and also done PG Diploma in Taxation Law and PG Diploma in Cyber Law. Currently, she is working as associate professor. Her academic credentials are PhD, LLM, LLB, BSc, and many more. Her educational achievements are: she stood second in merit list of Dr. Babasaheb Ambedkar Marathwada University, Aurangabad in LLB final year, May 2005. She is the topper of B.N. Patil Law College in LLB final year, May 2005. She stood fourth in merit list of Dr. Babasaheb Ambedkar Marathwada University, Aurangabad in LLB first year, May 2003. She also received Best Student of B.N. Patil Law College, Aurangabad 2003 to 2004. She is the topper of B.N. Patil Law College in LLB second year, May 2004, and also the topper of B.N. Patil Law College in LLB first year, May 2003. She has worked on many books, and in her one of the publications is a book on cyber law and its application, one more book on cyber law and its application. She has various paper in edited books and journals, and she has been a member of various prestigious editorial board and committee members. Ma'am, I welcome you to this program, and we are very happy to go for this journey with you. Thank you, everyone.
Thank you, madam. Good morning, Dr. Shilpa Dongre, madam. I request you to kindly start with your session. Madam, Shilpa, madam, can you hear me? Shilpa, madam.
हाँ मॅम ते नेटवर्क इश्यू आहे थांबले आता जॉईन करतील परत.
अच्छा बोलल्या का त्या? ओके. Meanwhile, let me know who's going to express vote of thanks for today's session. Because roll number wise, people are not doing their task. So any volunteer who's going to express vote of thanks for today's morning session?
And if anybody ready, then okay. Otherwise, I will do.
Because otherwise it is very awkward situation to keep calling the names or calling the roll numbers and asking anyone to do the task. Because this is what it carries marks, and it is your one of the responsibilities as a participant that you have to follow the rules.
Then relating to introduction of afternoon's resource person.
पाटील मॅडम मी आफ्टरनून सेशनचं इंट्रोडक्शन करणार आहे मॅडम.
अच्छा ते काल तुम्ही मला हे केलं होतं ना?
51 रोल नंबर.
ओके. आणि वोट ऑफ थँक्स आता कोण करणार? आफ्टरनून सेशनचं तर आता हे झालं हे इंट्रोडक्शन.
मॅडम रोल नंबर 38 मी सकाळच्या सेशनचं वोट ऑफ थँक्स करतो.
चालेल सर. ओके. आणि
मराठीमधून.
आफ्टरनून चालेल, काही लँग्वेज इज नॉट अ बॅरियर, बट यू हॅव टू प्ले द रोल विच यू आर गिव्हन. बस तेवढंच आपण अपेक्षा.
मॅडम आफ्टरनून सेशनचं इंट्रोडक्शन आणि वोट ऑफ थँक्स सुद्धा मीच मानणार आहे मॅडम.
तुम्हीच करता का?
हो
अच्छा.
हो मॅडम.
अच्छा, चालेल, काही हे नाही. पण अपेक्षा अशी असते की प्रत्येक पार्टिसिपंट जो आहे त्यांनी पार्टिसिपेट करायला पाहिजे सेशन मध्ये. आणि आपण सगळे टीचर्स असल्यामुळे हे काही याचं डिफिकल्ट टास्क तर आहे नाही. आणि वी डोंट इन्सिस्ट ऑन एनी लँग्वेज, आहे की नाही? आज आपल्याला ह्याची सवय आहे.
मॅडम
येस.
हॅलो मॅडम, प्रेझेंट झाली का मॅडम?
प्रेझेंट गौरव, आर यू देअर? Present is a task. Present is a task, so you are more bothered about your attendance than participation. I am not answering. I know की प्रेझेंटी होणार आहे की नाही, पण यू आर मोर कन्सर्न आज प्रेझेंटी होणार आहे का, मी प्रेझेंट आहे, चॅट मध्ये लिहून टाकायचं असं सगळं. अरे शेवटचा दिवस आहे आज तरी. आणि वी कम टू आपल्याला पार्टिसिपेंट्सचे नंबर आणि सगळं दिसतं. आम्हाला माहिती आहे कोण कोण अटेंड केलेला आहे. बट अगेन हा कन्सर्न जरुरी आहे तुमचा, आणि त्याच्यासाठी गौरवशी तुम्ही हे करा. आजचं अटेंडन्स हे तुमच्या पार्टिसिपेशनवर आहे, ठीक आहे? आणि तुम्ही टेस्ट दिलेली आहे मला वाटतं सर्वांनी. सर देअर इन वी नो यू आर प्रेझेंट अँड आय होप तुम्ही व्हॅलिडिक्टरी पर्यंत प्रेझेंट राहा, बिकॉज आजचा शेवटचा दिवस आहे आणि सर्वांनी प्रेझेंट राहावं आणि स्वतःच्या सर्टिफिकेट्स व्हर्च्युअली घ्यावा. दिस इज व्हॉट वी आर होप.
गुड मॉर्निंग मॅडम, मी डॉक्टर संगीता भामरे.
हा.
आजच्या शेड्यूल मध्ये रिपोर्ट रिडिंग होतं, तर त्या संदर्भात काही गाईड कराल?
रिपोर्ट रिडिंग आज एक्झाम असल्यामुळे तुमचा तो जो टास्क आहे ना तो
Okay.
हे केला गेला. हा,
बरं,
कारण
बरं.
की होल टाइम गॉट इन टू दॅट एक्झाम आणि ते
बरं,
फार
काही
असे
हरकत नाही मॅम, काही हरकत नाही. ओके ओके.
तुम्ही सबमिट केला असेल
हो,
सर्वांनी
yes,
रिपोर्ट.
yes. हो
सो
हो,
दॅट
रिपोर्ट इज सबमिटेड मॅम. केलाय. थँक्यू मॅम.
I'll check what is the situation with our resource person and get back to you.
I'm here, ma'am. Madam, am I audible?
Yes, ma'am, you are audible. Madam, please, you can start with your session.
Madam, let me allow to share the file.
Yes, madam. गौरव मॅडम शेअर करतायत त्यांची स्क्रीन.
गौरव केलं अलाव? गौरव?
होत नाही का तुमचं मॅडम?
नाही मॅडम.
ओके, एकच मिनिट. I'll talk to him. Madam, he is trying. There is some technical issue with the network.
Okay, ma'am.
He will allow you. We'll have to just wait because he is working on
I
it.
have sent the request also, madam. If
Uh,
request will be accepted, it has
yes,
been
yes.
declined.
Ma'am, there are others.
Uh,
Please.
Okay. Is it visible?
yes, ma'am.
Yes, madam.
Yes, ma'am.
Okay. A very warm good morning to one and all. First of all, I would like to
Good morning, madam.
Good morning. First of all, I want to extend my gratitude towards the UGC MMTTC Center, Dr. Babasaheb Ambedkar Marathwada University, and coordinator, STC coordinator, Dr. Nandita Patil Madam, for giving me this opportunity. Now, in two sessions, we will try to cover the all aspect of the data privacy. Now, we know that why data it is important. We will focus on understanding why privacy has become constitutional, legal, human issues in the age of artificial intelligence and digital technologies. Every day, from moment we wake up, we interact with technology. We unlock our phones using fingerprints or facial recognition, check emails, make online payments, use navigation apps, as well as attend virtual meetings and post on the social media. Most of us hardly realize that every one of these actions generate personal data. Now we know that how these they are generating the personal data already. Whatever apps we are using, by way of that they are generating our all this data. Even digital economy thrives on data. Government uses our data for governance. Business uses it for marketing. Artificial intelligence uses it to make the prediction and recommendation. Because data has become such valuable source, it has often described as the new oil. However, unlike oil, personal data represents real human beings, their identity, dignity, and autonomy. As teachers and academicians, we are not only users of digital technology, but also custodian of our students' personal data. We collect admission details, attendance record, examination result, research data, health information, and increasingly data generated through learning management system. This places a significant ethical and legal responsibilities upon us. Today's discussion is not merely about technology, it is about protecting human dignity in the digital society. So, while dealing with this, we will try to cover all the aspects. What we will cover in this today's session, we will see some learning objectives. First of all, we will try to understand the data privacy. As I had told, what do you mean by the data? So after that, we will first learning outcome will be the data privacy. Many people confuse with privacy and the secrecy. Privacy does not mean hiding something wrong. Rather, privacy means having control over your personal information and deciding who can access it for what purpose and how long. Second learning outcome, it is to know the different key aspects like privacy, data protection, data security. These terms are oftenly used interchangeably, but legally they are different concepts. Then third outcome will be constitutional basis of privacy in India. This is particularly important because in 2017, Supreme Court declared privacy to be a fundamental right under Article 21. And we will also discuss the Article 14 and 19 also. Fourth learning outcome, it will be the ethical dimension of data handling. It is most important. That's why ethical dimensions, it will be seen. Fifth learning outcome, it will be, under this we shall identify emerging digital privacy challenges, including artificial intelligence, big data, social media, Internet of Things, deep fake, and digital surveillance. And sixth outcome, it will the role of the teacher. As we are working as the teachers, professors, as an educator, we are role models. If we ourselves do not follow ethical digital practices, it becomes difficult to teach student responsible technology use. Therefore, today's session, it will not merely the academic, but it will have some practical knowledge also. Now, just tell me, how many of you are using the different types of apps? How many applications are involved on your smartphones? Can you guess? Less than 20, 50, more than 50? Yes, anyone? Am I audible?
Yes, ma'am.
Can you tell me how many applications have been used? It has been installed on your phone?
For myself, it is more than 25.
More
It
than
depends upon everyone. Yeah.
Now see here, we have so many applications which has been generally installed on our phone. Now just think for a minute. We are generally, most of the participant, or I will say all the participants, are using the smartphones, and most of them having more than 25 applications. And some peoples, they are having more than 80 applications. Now let me ask one question. How many you have actually read the privacy policy before clicking I agree? Generally, we are not reading it. Have you read the policies?
No, ma'am.
No, ma'am.
No. We have not read the policies before clicking I agree. Now see here, why it is they are saying that I agree? Definitely there is a reason behind it. As Data Protection Act, it says that unless and until you are taking the consent of the person, you cannot take their data. And that's why we are generally asking to agree the privacy policy. So here, usually, most of the persons, they are not reading this privacy. So here, the biggest problem of digital age, we routinely consent without understanding. Now the question is that how many apps currently have your access to camera, location, microphones, contacts, and file? Most people never check this permission. And I must say that there are some apps without giving the permission to the access of camera, location, contacts, microphones, or the files. They are also all these apps, it has not been generally installed. So yet every permission provides access to visual personal information. So here our data, it has been generally collected by all these apps. Now we'll see what does data privacy matters. In every single day, consciously or unconsciously, we share different categories of personal information. For example, when we open a bank account, we provide our Aadhaar card, PAN cards, address, mobile number, and photographs. When we book a railway ticket, our travel history, it is recorded. When we use Google Maps, our location is continuously tracked. Our preferences are analyzed. When we shop online, our buying behavior become valuable business data. Hospital collects medical histories, university collect examination record, bank collect financial information, social media performs collect behavioral information. So we can say that every click creates a data. Each and every click, it is creating our data. Every search creates data, every print creates data. This is why data has become one of the world's most valuable economic resources. Now, some people says that data is a new oil. Never, why it is saying that data is a new oil? Because modern and artificial intelligence system cannot function without the data. Businesses cannot personalize services without data. Government cannot provide the digital governance without data. However, unlike oil, personal data belongs to individuals. Therefore, misuse of data directly affects human dignity. The data breach can lead to identity theft, then financial fraud, blackmails, cybercrime, reputational damages. Therefore, protecting personal data is no longer optional. It has become essential for a democratic society. Now, for example, suppose university accidentally publishes students' Aadhaar card. Then they also accidentally publish examination records online. Then what happens? Here student may become the victim of the fraud. Again, there is a issue of the privacy. His privacy is violated. Institution may lose credibility, and data privacy protects individual as well as the institutions. Now let us understand what exactly data constitutes. Now, if you will see what is data and types of data, before discussing privacy, we first understand what exactly data means. Data simply means facts on information collected about an individual. For example, name, address, Aadhaar card number, PAN card number, mobile number, email address, IP address. See here, IP address, it is also one of the data. Then GPS locations, biometric, which has been used everywhere for doing the KYC or for filling the government's different types of form. Browsing history, it is very important. When browsing history, on the basis of browsing history, we are getting the some types of notification. For example, if we are browsing some particular thing for the shopping, all the sites regarding that particular thing, it will come. Then health record, biometrics, all these constitute the data. Not all personal data carries the same level of sensitivity. Therefore, we generally distinguish data as a personal data, then sensitive data, as well as the critical data. Now, if you see personal data, it includes our all personal identity, including name, address, email, student IDs, then employee ID. Now, if you will turn towards the sensitive personal data, now these include more information that requires higher protection. Now, why it requires the higher protection? First of all, we will see sensitive personal data. These are the medical information, then financial records, passwords, fingerprints, facial recognition data, genetic information, religious belief. If sensitive data is leaked, the consequences can be more serious than disclosure of ordinary personal data. As a teacher, we regularly handle both categories. For example, attendance register, which contains the personal data like name of the student, then mobile numbers, email address. Then medical certificates contains the sensitive data. Sometimes we know that students are absent due to some medical issues, so they are giving us medical certificates for allowing him for the examination or some other purposes. So these medical certificates or medical data, it is also collected by us also. These scholarship records. This scholarship records, it contains the financial data. So as a student, as a teacher, we are collecting the personal data, financial data, sensitive data of our student. Research involving human participants may include highly sensitive personal information. Hence, educational institution must adopt different level of protection depending upon the nature of the collection. Just tell me, can examination marks be considered as the personal data? What do you think? Yes, anyone? Can examination marks can be considered as the personal data?
No, ma'am.
It is not personal data?
No, ma'am.
Yes, ma'am. It is.
Yes, it is personal data. Examination records identify students, their intellectual. That's why it qualifies as the personal data. So we should not generally publish it, but whenever it is necessary, as I have told that definitely data it has been collected, and as we are living in the digital age, without data, this digital governance, it is not possible. That's why even though personal, this examination marks, it comes under the personal data, but whenever necessary, this data it is to be published. But when it is to be published, at that time there are some rules which are necessary, and we must follow all these rules. And if we are following all those rules, then definitely it will not be the violation of the privacy. Now next we will see, now we will understand that data means, now we will distinguish three important concepts that are often confused. All those concepts are privacy, data protection, and data security. Most of the people thinks that privacy, data protection, and data security, these are the same concept, but legally they are not same. First concept, that is the privacy. Privacy, it is about the individual's right to control personal information. Here, we can control our personal information. Here the question is, who should have access my information? So privacy, as I had told that privacy, it is mean controlling our personal information and decide who will have the access of our information. So for example, should every teacher be allowed to see the student's medical record? Certainly not. Each and every teacher must not be allowed to see the student medical record. The person who are concerning with this particular issue, only that teacher must be allowed to see the student's medical record. Only authorized person should have the information to this sensitive data of the student. Therefore, privacy focuses on individual autonomy and choices. The second concept, that is the data protection. Data protection refers to the legal and administrative framework governing the collection, storage, use, sharing, and deletion of the personal data. Now, whenever we are we will say the data protection. Generally, law, rules, regulations, government policy, or all these things come into the picture. Even there must be some university policies for the data protection. Now, if it answers the questions that in the data protection, why the data is being collected. Second thing is that is consent required for collecting this data? How should long the data shall be retained, and who is legally responsible for protecting the data? So all these concepts need to be answered for protection of the data. For universities, this includes admission policies. So we can say that data it is collected for the admission policies. Then examination regulations are there, and definitely the student are giving the consent for that. How much time this data it is to be retained. If you will see the examination record, generally it is to be kept for the even including the exam internal assessment records and marks, it shall be kept for 5 years. Even it is the issue of that particular institution, how much long they want to protect that particular records also. So here, examination regulations, institutional procedures governing students' information, and all these comes under the data protection. Now, third concept, that is the data security. Data security concern the technical measures used to prevent unauthorized access, alteration, as well as loss of data. Now see here, whenever we are saying data security, here all the technical things it will come into the picture. Now here it requires some cybersecurity measures also. All it will includes the strong password, then encryption shall be there, firewalls protection, secure cloud storage must be there, multi-level authentication it shall be given, antivirus software it must be installed, and regular backup it is to be taken for the security of the data. Security is the technological mechanism that supports privacy and data protection. As we know that generally all the teachers they have to do the work of the NAC also, and for that purpose, as we know now, NAC it can be done online. So the data security is the most important thing for all we teachers, because whatever things it is to be given, it must be given online, and for that purpose the person who is having the charge of that all these things, he must keep all this data in the security. He must use the antivirus software, strong password must be kept for accessing his particular device. Even regular backup it must be taken. Now if we will take one classroom illustration. Imagine that university maintains examination records. Now privacy asks who is permitted to view the marks. If examination records it has been maintained by the university, privacy says that who is permitted to view the marks. Data protection asks what institution rules regulates access, storage, and sharing of these records. And in data security, it asks what technical safeguard such as password, encryption, or secure severs prevent authorized access. All these three concepts works together. Strong security without legal safeguard is insufficient, and legal safeguard without technical security are ineffective. Suppose a teacher shares student marks in a public WhatsApp group. Is this a privacy issue? Is it a data protection issue? Is it a data security issue? Definitely it is. But here, if a particular data protection policies says, then definitely it can be. But generally, here we can say that data protection, privacy, and data security, all these three concepts are interlinked. Having distinguished these three concepts, we are now ready to trace out how the idea of privacy have evolved. Evolution of the privacy from protection of physical space to protection of our digital identity in the era of artificial intelligence. This is focus on this slide, evolution of the privacy. Now it shows traditional society, after that information age, AI era, and future also. Now that we understand the difference between privacy, data protection, data security, let's examine the meaning of privacy has changed over times. Privacy has never been a static concept. It has evolved alongside society and technology. The concept of privacy has transformed dramatically over the centuries. What privacy means 50 years ago is very different from what is today mean. First is traditional society. Here in traditional society, privacy was as a physical space. People were concerned about protecting their homes, personal letters, family life, and personal conversation. Because before the 50 years ago, this digital data, this was not the concept. And that's why the privacy, it was only meaning of the physical privacy. So here people were generally protecting homes, personal letters, family life, personal conversation. Now if someone enters your house without permission to read the private letters, then here we can say that privacy it has been violated. At that time, information was mostly stored on paper, so making unauthorized access relatively difficult. Even there were no any paperless work before the 50 years, and that's why privacy, this issue, it was stick to the physical space only. For example, imagine someone opening your personal diary without permission. Definitely, here we can say that it is the violation of the privacy. Even though no technology is evolved, your privacy has clearly been violated. Now, second, we will see in the evolution of privacy is information age. Here, privacy, it is nothing but the information. Privacy as information, we will see. With the arrival of computers and the internet, privacy extended beyond physical space. Today, our information exists in digital form. Every time we send an email, make an online payment, use Google Maps, book railway tickets, then shop online, we generate our digital information. On a single click, every click, we are generating our digital information. Privacy now means controlling who can access this information. Our digital identity has become as important as our physical identity. So here, the concept of privacy, it has been changed from physical space to information. Now, third era, that is of artificial intelligence era. Now, in this artificial intelligence era, we will see privacy as a behavior prediction. How it is behavior prediction? Because AI, it is totally depend upon the data collected day by day, and whatever day by day data it has been collected, it has been stored. Even our physical behavior pattern, it has been generally one type of data for AI. Today we are entering an entirely new age. Artificial intelligence no longer merely stores information, but it also analyzes our behavior. This artificial intelligence system studies what we buy, what we search, what videos we watch, how long we spend reading an article, with whom we communicate with, where we travel. Now, using all this information, AI predict our future behavior. Now, for example, if we are searching for a particular gift, we can take the example of a wristwatch. If we want to buy a wristwatch and we are searching, then definitely after some time we will get all the notifications or all the advertisement regarding the wristwatch, and that is from the different companies, from the different website. So here this AI is analyzing our behavior, and that's why whatever we are buying, whatever we are searching, what type of videos we are watching, all these things, it is nothing but the data for the AI. And using this information, AI predict our future behavior. Now we can take example. Most of the people must have having the OTT platforms. So Netflix, it predicts which movie you can enjoy. Netflix is there. We know that Amazon is also there. That Prime is also there. Might be you have experienced that if we are watching a particular movie and that is comedy movie, then this OTT, they are giving same type of movies and they are giving one message because you watch this movie. Have you experienced this? Can you answer, anyone? Have you experienced? If we are watching a particular movie, then these platforms, they are showing all these types of same type of movies. Or you must have experienced that whenever you are searching a particular one information, we are getting the same type of information. Now we'll see in the evolution of privacy, as we have seen, first of all, privacy as a physical space, then privacy as information, privacy in AI as a behavioral prediction. Now we will, in future, privacy as a digital identity. Now, future of the privacy, it is centered in our digital identity. Now we are having our identity, but in future, our identity will be totally digitalized. Increasing our identity is verified using our fingerprints, facial recognition, iris scan, video recognition, digital credential. So our digital identity is becoming inseparable from our everyday lives. Therefore, protecting digital identity is becoming synonymous with your protecting personal liberty. Now we know that most of the times we are using our fingerprints, facial recognition to unlock the mobile phones. Tell me how many of you using only patterns to unlock the mobile phones? Yes, or everyone is using fingerprints or facial recognition? Is there anyone who do not lock the phone? Am I audible? Yes, participant.
Yes, ma'am.
What do you use generally? Fingerprints, facial recognition, or a pattern to unlock the phone?
Fingerprint, ma'am.
Fingerprints. So
Fingerprint.
we can say that we are giving our digital identity because it is very easy by way of fingerprints, or we can say that facial recognition, even iris scan is there, some voice recognition. So here by way of that we can unlock our phone. So we are giving our physical identity. So we can say that our physical identity is becoming inseparable from our everyday lives. Therefore, protecting digital identity is becoming synonymous with protecting personal liberty. Now, here, privacy is the right to control information about oneself. This is perhaps the simplest and most powerful definition of the privacy. So we can say that privacy, it is nothing but right to control information about oneself in the digital era. Privacy is not about something, hiding something. Whenever we are hiding something, it says that it is secrecy. But privacy, it is not the hiding something. It means controlling our own information. Now tell me, if someone traces your online behavior without informing you, has your privacy been violated even if your name is not disclosed? Definitely yes. Because our behavior information itself can reveal the person's identity as well as the preferences. Having understood the evolution of privacy, let us now examine how the Constitution of India protects these important rights. Is anyone who does not know the Constitution of India? And we know that we have guaranteed with the numbers of fundamental rights by the Constitution of India. So we must have some glance on this constitutional foundation of the privacy. Many people think that privacy is only a technological issue. Actually, privacy is fundamentally a constitutional value. Constitution of India does not explicitly mention the word privacy. However, through the various judgment which has been given by the Supreme Court, privacy has recognized as an essential part of our fundamental right. Now, if we see the Article 14, that is the equality before law, Article 19, freedom of speech and expression, and Article 21, that is the right to privacy, which has been included in the right to life and the personal liberty. Yes. Article 14, it guarantees the right to equality before the law. Privacy protects equality because misuse of personal information can lead to discrimination. For example, suppose an employer rejects the candidates after discovering the confidential medical information without the consent. This raises an issue of equality. Because here we can say that if AI is we can take another example. Now suppose there is a one person who were having a case file against him. So it will show that that person having a criminal record. So it has been generally already feed this information by the AI. When employer goes and check the history of that particular candidate, it shows that some criminal case has been booked against him. Now, because of this, if his job it has been rejected by the employer, so here we can see that discrimination. It might be possible that he has been acquitted from that particular charges there, but it has not been uploaded online. That's why these AI do not know he has been acquitted. So here the right to equality, it gets violated. Now, second article, that is the 19, which guarantees us the freedom. So Article 19 guarantees several freedoms, including freedom of speech and expression, freedom of movement, freedom of association. Can individual exercise these freedoms if they are constantly watched? Definitely not. Because here we can say that continuous surveillance discourages free expression. Sometimes we think that if we will express something, if any person will have the video recording it, it can be forwarded, then definitely my image, it will be demeaned. That's why the people generally not exercising their freedom of speech and expression without any fear. People begin censoring themselves. Even we can say that privacy strengthens democratic freedom. If, as we know that everywhere surveillance camera it has been installed. So whenever surveillance camera it has been installed in the public places also, at that time what happens? We think that if we want to support a particular protest, then we will think that if I will go there and if I will be captured by those cameras, then definitely here I will be targetized by some people. So we'll think not to go there. So definitely here our freedom of movement it get violated. That's why even freedom of speech, all these Article 19s which gives the freedom, it gets violated because of the issue of the privacy. Now we will see the Article 21. Article 21, which is the fundamental right, it guarantees right to life and personal liberty according to our constitution. Now this article says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now here Supreme Court has interpreted life broadly. Supreme Court has said that life, it does not only means a physical existence. Life means dignity, to live with the human dignity, then autonomy, reputation of a person. A person must have the choices and privacy. Without privacy, personal liberty, it becomes meaningless. Now we'll turn towards the human dignity. If you see human dignity, then autonomy, privacy, liberty, all these sequence, it explains the privacy. It is not an isolated right. It supports every aspect of human being. Now we'll take some classroom example. Suppose student counseling records are published publicly. Has only confidentiality been violated? Now see here, suppose we know that sometimes we need to counsel our student. When we need to counsel the student, here we will have some records also. So it should not be published publicly because it violates the confidentiality also. Here, students' dignity, autonomy, liberty, it also get affected. These are the constitutional recognition of privacy. It did not happen overnight. How the constitution, they have given the right to privacy as a fundamental right, it evolves through a series of landmark judges. Now we will have a glance on some of the decisions which has been given by our Supreme Court. It is called as the landmark judgment. Very first case is the Govind versus State of Maharashtra. Under this, here, first time, judicial recognition of privacy came in India. Now here, in this case, Govind, he was under the police surveillance in the night also. Here he was charged, after that he was acquitted, but still police was having the surveillance on him in the night also. They used to visit him at the night. So here he filed a case and he said that police surveillance at my home, even in night, it gets the violation of my privacy. So this is the first important judicial recognition of privacy. Although the Constitution did not express mention the privacy, the Supreme Court acknowledges that privacy could not be deprived of Article 19 and 21, that is the right to freedom, speech and expression and right to life. This case involves a police surveillance regulation. They said that definitely police have the right to surveillance to watch whether the particular person who has been charged with that offense is doing something wrong or not. But this surveillance must have some regulations. Police are the petitioner, that is the Gobind, he argued that excessive surveillance interferes with personal liberty. So in this, Supreme Court has given some important observation. Supreme Court stated, privacy is an important constitutional value. However, privacy is not absolute. Definitely, whatever right it has been guaranteed to us, it is not absolute. There are some reasonable restrictions and it must be imposed in the public interest. Now, this remain true today. No fundamental right is completely unrestricted. Now, for example, government may collect lawful information. When they are collecting this information lawfully, they can collect this information during criminal investigation, for national security operations, public health emergencies, but such action must satisfy constitutional standard. So here, this Gobind laid down foundation for India's modern privacy jurisprudence. Later, judgment built upon these principles. The next judgment expanded privacy beyond surveillance and addressed publication of personal information. Now, this case, it is the R. Rajgopal versus State of Tamil Nadu. It is also known as the Auto Shankar case. In this, the issue was whether government could prevent publication of an individual life story. So here, Supreme Court held that every individual possesses the right to control publication of personal information. Here, government was trying to publish the story of the Auto Shankar, that is the Rajgopal. So he said that it is my personal choice whether I want to share my personal information with other person or not. So, principle established in this judgment is individual have a right to control disclosure of personal information. Whenever he want, he can publish his autobiography, he can publish his personal story. But if at this time he don't want to disclose his personal information, then definitely here no one can force him. Then to prevent unauthorized publication, again to protect their reputation. However, information contained in public records may be published. See here, whatever public records are there, and in public records, if information it has been given, it can be published. Now, for example, here we can say that if there is a particular criminal, how many offenses he has committed, after that, what type of punishment he has been given, all these can be a public record. But how many children he is having, what is his qualification, under what circumstances he has done his education, all these are the private records, so it cannot be published. Thus, privacy and freedom of press, it must be balanced. Now we see some modern relevance. People frequently post others' photographs on social media without consent. I think we all are posting the photographs on social media. What I'm saying that others' photographs, and that is on social media without consent. Is it posted by anyone? Definitely by everyone. Am I correct? If we are going for a particular picnic, we are having the college programs, what we are doing, we are keeping our status on the WhatsApp. We are publishing on the Facebook or LinkedIn is there. Are we taking the permission of our colleagues while posting these photographs? Yes. Are we taking the permission?
Yes.
Taking the permissions before posting the photographs with others?
Yes, ma'am.
No.
If we are not taking, definitely it is the violation of the privacy. And most of the persons, what we are generally doing, we are without any permission, we are posting or we are uploading it. Now, whenever these new portals, it often disclose private information. Now here, in this case, judgment reminds us that personal information belongs to primarily to an individual. Suppose a university uploads students' disciplinary record on its public website. Would it be violate privacy? If university, or we can say that our the institutions like the college, they are uploading the students' disciplinary records on a public website, on the college website. What do you think? Is it the violation of privacy or not? Yes, anyone?
Yes, it is, ma'am.
Yes, it is violation unless it is legally justified. So whatever information which is not required, which is not compulsory, if we are publishing, then definitely it would infringe the privacy of a particular student. But if we want to upload it, then definitely it must be legally justified. Now here we can say that, does becoming famous means losing all privacy? Definitely, we can say that public figure retain their privacy regarding personal matters. We can say that becoming famous, it is not the losing privacy, but what type of personal things it should not be published and what we can control by publishing, all these matters comes under the privacy. Now next landmark judgment extended the privacy protection is, that is telephone conversation. Today, with changing rapidly during 1990s, telephone communication become common. Now, instead of telephone, I will say the mobile communication, but this case, it is of 1997. And at that time, telephone landlines was there. So here, telephone communication as it was common. The question was before the court that, can government intercept telephone conversation without the safeguards? The court answered that telephone conversations are private. Interception is permissible only under the strict legal conditions. Now see here, if we are asking the telephone records or the conversation record, then definitely CDR, or we can say that the call data records, it shall not be given to anyone unless and until it has been asked by the person who is having that mobile number. And if we are asking for some telephone records or mobile records, then definitely there must be some rules and regulation. Unless and until it is not necessary, all these things it must not be provided. So here there are three important principles. Government surveillance, it must satisfy legality. Three tests are there: legality, necessity, then procedural safeguards. Legally, there must be some authority for telephone tapping if it is necessary. Now, for example, it is necessary for the national security, then definitely we can say that it can be tapped, otherwise not. And procedural safeguard, there must be checked against this particular, there must be the check regarding this telephone tapping, or whenever we are saying that if all these three aspects it has not been taken into consideration, then definitely it amounts to the violation of the privacy. Now, privacy extend to communication. As we know that here we understand what do you mean by the data, then how it can be collected, then why it is necessary. Now we will turn towards the next case, Selvi versus state of Karnataka. Now see here, as I have told that there are different aspects of the privacy from physical to digital age. We have seen the data, it has been changed, aspect of the privacy, it has been changed. Now we will see this Selvi's case. Generally, it comes under the behavioral pattern. As I have told that AI is there, and what AI is doing? AI is generally collecting the data, and when it has been collected, it is totally identifying the patterns. Now, in Selvi versus state of Karnataka, if you see, the issues are regarding narco analysis, polygraph test, and brain mapping. Do you know all these things? Have you heard about it? Yes, anyone? Have you heard about the narco analysis, polygraph test, or brain mapping test? Can it done without the consent of the person or without the order of the court? What do you
No,
think?
ma'am. Without court,
Without court's
without
permission?
court,
No,
it is
ma'am.
not possible.
Yes. Without court's permission, it
Mm.
cannot be done. So, in this important case, here the issue before the Supreme Court was whether investigating agencies could compel individual to go the narco analysis, then polygraph test or brain mapping without their consent. Supreme Court said that such tests cannot be conducted without voluntary consent. Now, why? Because it violates the constitutional fundamental rights. Every accused has the right against the self-incrimination. Means no person can be forced to provide evidence against themselves. It has been guaranteed under Article 20, Clause 3. Now tell me, have you seen a particular investigation in the television, in a movies, in a serial, which has been done by the police and they are using the third degree torture, third degree method to extort the confession? Yes. कधी बघितले का पोलीस स्टेशनचे जे काही सीन्स असतात इन्व्हेस्टिगेशन करताना पोलीस अथॉरिटी जे आहे थर्ड डिग्री मेथड यूज करतात?
No, ma'am.
In movies, in serials, definitely there would be no any chance that we will see it live or directly. मूवी सीन्स मध्ये वगैरे टीव्ही सिरियल मध्ये आपण बघितलं असेल ना कधी पोलीस दे आर डुईंग द टॉर्चर.
Yes, ma'am. Yes.
Patient. Now see here, even the police is taking the confession by way of force. What happens? पोलिसांनी जर असं कन्फेशन घेतलं असेल, it is not reliable in the court of law, because the right which has been guaranteed of the self-incrimination, that is no person can force to provide evidence against themselves. Then second one is that personal liberty, it includes mental autonomy. The state cannot evade an individual's mind because constitutional justification. So here the court said that without the consent of the person, any type of this test, it cannot be done. The Supreme Court expanded the privacy beyond physical body, personal information to mental privacy. Now see here, there is narco analysis, polygraph test, brain mapping. It generally violates the mental privacy if it has not been done without the if it has not been done with the permission of the person. Now we will see real life connection. Today AI system increasingly analyzes our emotion, facial expression, voice pattern, behavioral traits. As technology become capable of inferring thoughts and emotion, this case of Selvi reminds us that even our mental autonomy deserves constitutional protection. Now we have seen that sometimes we are watching or listening songs for a happy mood, then definitely if auto mode it has been selected, we are getting the same type of happy mood songs. But if you are listening the songs which are we can say that regarding the party, then definitely it will give the same type of song. So here we can say that they are generally not identifying our behavioral patterns, but it is trying to violate our mental autonomy also. If technology can predict our emotions or intention, should there be any legal limit on use? What do you think? If they are controlling our emotions, their intention, then definitely there should be some limits on all these things. So far as we have seen, these Indian courts, they have given how privacy it is important. Now let us discuss the landmark decision that finally declares privacy as a fundamental right under the Indian Constitution, the historical Justice K.P. Puttaswamy's judgment. The case is Justice K.P. Puttaswamy. Now, until we have seen now, in this case, the 9 judges constitutional board bench of Supreme Court is delivered one of the most constitutional decisions of Indian legal history. In this judgment, fundamentally changed the legal understanding of privacy in India. The issue before the court was whether right to privacy is a fundamental right guaranteed under the Indian Constitution. Unanimously, it has held that privacy is a fundamental right protected under Article 21 and is closely linked with Article 14, 19, and they have overruled all decisions which says that Constitution, under the Constitution, right to privacy, it has not been recognized. Now, this case, it is regarding the biometric or Aadhaar case. First time when Aadhaar it was introduced in our country, it was taking our all biometric information. Do you know which type of our information it has been taken by the while having the Aadhaar card access? When we are going for the Aadhaar, or if now each and every person is having the Aadhaar, if we want to update it, what personal information, identity information it has been collected by the Aadhaar? One is biometric. Again, आधार मध्ये अजून काय कलेक्ट करतात सांगू शकाल? आधार कार्ड अपडेट करायचं असेल, आधार काढताना काय काय कलेक्ट होतं? कोणती कोणती इन्फॉर्मेशन, पर्सनल इन्फॉर्मेशन विच रेकग्नाइज अवर आयडेंटिटी?
Yes, birth, place, date.
आयरिस, डोळे स्कॅन करतात, आयरिस स्कॅन इज देअर, फोटोग्राफ्स घेण्यात येतो, देन अवर फिंगरप्रिंट्स. सो all these things it were generally taken. So the case was filed that this collection of our information, it is violative of nothing but the right to privacy. So Supreme Court in this case, they have declared that privacy protects human dignity, personal autonomy, informational privacy, freedom of choice, liberty against arbitrary action also. Privacy therefore extend beyond physical space. It protects the individual's ability to make personal decision without necessary interference. Now, if we see the informational privacy, one of the most significant contribution of this judgment was recognition of informational privacy. Today, government, then businesses, university, hospital, and digital platform collect vast amount of personal data. The court observed that individuals have a legitimate expectation that such information will be handled responsibly. Now here, if this information is handled with responsibility, then in such cases, violation of privacy, it will not affected. This principle forms constitutional bias from modern data protection legal legislation. Now, in this case, as it was said that definitely this collection of data, it violates the right to privacy, but at the same time, if it is collected and for a particular purpose, according to the law, then definitely it do not violate the privacy. So there is a connection between this case and the Digital Personal Data Protection Act. Here, although the Constitution does not expressly mention data protection, recognition of privacy, it is the fundamental right which has encouraged the Parliament of our India to enact a comprehensive legal framework governing processing of personal data. For example, suppose university collects students' biometric attendance, questions immediately arises. Why is data being collected? Is the collection necessary? Who has access? How long it will be stored? Is student privacy adequately protected? So here this questions flows directly from the constitutional principles which has been articulated in the case of this Puttaswamy. Now, give me the answer. Can digital convenience satisfy ultimately collection of personal data, unlimited collection of data? In the name of digital convenience, can we collect the unlimited data of our student? Can you tell me? We are collecting the data. Now, I think most of the colleges is having biometric attendance. Is it violation of privacy?
Yes, it is.
But if here it is being for keeping their records of attendance, and university is giving us this permission, so can we say that it is the violation of privacy? And if we are saying that it will be accessed only by the college, whenever it has been asked by the university, it will be given and it will not be published anywhere, then definitely it do not violate the privacy. So here we can say that here collection of data, it is not only the issue of the privacy violation, but how it will be used, for what purpose, without our permission. Here, if private policy it has been changed, then we can say that it is the violation of the privacy. Now we have seen the constitutional aspect. Now we'll turn towards the privacy aspect.
Aruna, mute your mic.
Constitution of India protects privacy. Privacy, it is also recognized internationally as a basic human rights. Now let us know the global aspect of this privacy concept. Universal Declaration of Human Rights, under this Article 12, it protects the privacy, and it has generally said that it is one of the human right. Privacy, it is nothing but one of the human right. Article 12, it says that no person shall be subjected to arbitrary interference with his privacy. Now see here, if it has been said by the Universal Declaration of India, although it is not legally binding, but it has greatly influenced constitutional and human rights laws across the world. International Convention on Civil and Political Rights, under this Article 17, it similarly protects the individuals against arbitrary or unlawful interference with privacy, family, home, correspondence. India is party to this International Convention on Civil and Political Rights. Therefore, it shares the commitment to this human rights principle. Now, if we see why privacy matters globally, as we are seeing that privacy in a global world, here the privacy supports freedom, dignity, then democracy, human development. Without privacy, individuals may hesitate to express opinions, communicate freely, or participate confidently in public life. Now imagine a society where every email, every phone call, classroom discussion, and internet search is constantly monitored. Would people express their controversial opinions? If we are going to monitor, then can we express our controversial opinion? Would academic freedom flourish? Definitely not. We will say that If we are going to make a controversial opinion, then definitely it may create some problem in future. So we will not express our controversial opinions also. So privacy therefore creates a space necessary for intellectual growth and democratic participation also. Here the question arises, can democracy survive if citizens constantly fear surveillance? Definitely not. Because privacy, it is connected with the freedom of speech and expression, even it is connected with the academic independence. So if there is a constantly surveillance by the government, then democracy cannot be survived. Having understood the privacy as a constitutional and international human right, let us now consider the ethical values that support it. Now, here we can say that these ethical values are the most important universal human values and the data privacy. Law alone cannot protect privacy. Even technology alone cannot protect privacy. Ultimately, privacy depends upon our own values. Here, it has been identified several universal human values closely connected with privacy. For example, respect, dignity, trust, equality, responsibility, all these human values are connected with the privacy. Respect, it is nothing but the acknowledging another person's control over their personal information. Before sharing someone's photograph, contact number, or personal detail, we should obtain permission. Then dignity, every individual deserves to be treated with dignity. Improper disclosure of personal information may cause the humiliation, discrimination, or emotion harm. Trust, digital education depends upon the trust. Students share information because they trust teachers and educational institutions. If confidentiality is breached, the trust is damaged. Equality, privacy protect individual from discrimination based on personal information such as health conditions, religion, or financial circumstances, and responsibility. This is the most important human value. Every digital user carries responsibility. Rights and responsibility always go together. We expect other to respect our privacy. Therefore, we must respect their also. Here, I have quote one line, technology must serve human dignity, not replace it. This is an important reminder that technological development should strengthen human welfare rather than diminish the human rights. These ethical values guides our professional conduct, especially as teachers interested with students' information. Now, this is the most important part. As a teacher, we must know the professional ethics in digital world. Educational institutions handle enormous quantities of personal information of our student. Therefore, the professors to teachers have ethical responsibility that go beyond legal compliances. Here, there are 6 important ethical principles. It has been shown in the slide. First one is the confidentiality. Student information should remain confidential unless disclosure is legally justified. Whenever we are having the student information, we must keep it confidential. If law is saying it is to be disclosed, then and then only we should disclose it. Second ethical principle which we teachers should follow, that is the transparency. Students should understand what information is collected, why it is collected, how it will be used, and transparency build the trust. Because we know that, as I have told, that privacy, it is nothing but the secrecy, keeping hiding, but having the control over our personal data. So student must know for what purpose information is collected, why it is collected, how long it will be used, for what purpose it will be used. So this transparency must be there. We should give them the first of all intimation for what purpose we are collecting this data. So transparency must be there. Then Ethical principle which need to be followed by the teachers is accountability. Educational institution must accept responsibility for protecting personal information. Every staff member plays a very important role in protecting the information of each and every student. So this accountability, it is the ethical principle. Next ethical principle in the digital age is fairness. Personal data should never be used in discriminatory manner. AI-based decisions should also be fair and unbiased. Next ethical principle is the consent, where appropriate individual should voluntarily agree before their personal information is collected or shared. And last ethical principle is the integrity. Professor or teacher should ensure that personal information remains accurate and protected against unauthorized alteration. It should not be altered whenever personal information it has been collected from the student. Now we'll see some responsibilities of the teachers. Now see, as a teacher, we are collecting data. We are trying to keep it secret also. So here, there are some responsibilities of the teacher. Teacher should protect student information, respect confidentiality, avoid collecting unnecessary data, and promote ethical digital behavior. This principle should guide everyday academic practice. Instead of, we will take the practical example here. Instead of sharing marks publicly through a messaging application, teachers should use secure institutional portal with appropriate access control. Now we know that some of the universities having the online assessment. Here marks it has been shared not publicly for each and every student on the website, but they are giving these marks in the personal accounts of the student. So here confidentiality it will be maintained. Every online activity leaves behind traces of information. These traces are known as digital footprint. Now we know that this digital footprint, it is nothing but whatever traces of information it has been left by us on the online activities or in the digital age. Have you ever searched from your name on the Google? Yes, participant. Have you searched your name on Google? Any participant have searched their name on the Google, on the search engine? Yes. Then go and search it. You will surprise that so many data it has been collected by the Google regarding us. If you have uploaded some data, if you have the Facebook account, if you have the LinkedIn account, then definitely here all this information it will appear by your name, including the photographs. So here this illustrates the idea of digital footprint. Every online activity it generates the data. Now we will take the examples. It includes mobile application, then websites, digital payment, GPS navigation, email, photographs, video conferences, and so on. So two types of digital footprints are there. One is active digital footprint and second one is that passive digital footprint. Information in active digital footprint, information intentionally shared. For example, social media posts, comments, uploaded photographs, online profiles. So we are sharing this information with our consent. Second one is that passive digital footprints. Here information is collected automatically by the AI. Now, for example, IP address is there, browsing history, device information, then location tracking, cookies. These are the all digital passive footprints. Many people are unaware that passive data collection occurs continuously. So these all data it has been collected automatically and continuously, even it get upgraded by the AI. Why does it matter? Our digital footprint may influence employment opportunity. Then insurance assessment, credit decision, targeted advertisement, and AI recommendation. For that purpose, this digital footprint is necessary to the AI. For example, suppose a student frequently searches for overseas universities. Soon advertisement regarding international education begins appearing. This is behavioral profiling based on digital footprint. Which is more dangerous? What is intentionally shared, like our photographs, or collected automatically? Like we are just have one particular search and they have collected it. Now see here, we can say that passive collection often present greater risk than the active collection. So here, passive information which has been collected, it is more dangerous because we are unaware what type of information it has been collected by AI. Now, we will turn towards the next slide, that is artificial intelligence and big data. Artificial intelligence, it analyzes these digital footprints to make decision and prediction. Now let us examine both its benefits as well as the risk. Artificial intelligence, it is totally depend upon the data. The more data AI receives, the more accurate its predictions become. AI analysis, behavior, preferences, then purchase, searches, locations, health informations. If you will see the benefits of AI, there are several benefits. Personalization, here streaming services recommends movie, shopping platforms suggest products, educational platforms recommends learning resources. Now better healthcare, AI assists doctors by analyzing medical information and identifying the patterns. Sometimes we are giving our reports to the AI. There are many habits of the persons. If they are having some dizziness, if they are sick, they are asking AI, what type of medicine should I take? Definitely, it should not be done. So here, sometimes AI can give us the wrong information. At the same time, they are collecting our health information, and which is high sensitive data. Now, if we consider the smart education, educational technology can personalize learning according to each student's progress and learning styles. Risk, despite these advantages, the significant concerns remains. We will see what type of risk are there. Surveillance, then profiling, bias, and privacy discussion. Suppose artificial intelligence rejects a deserving student for a scholarship because the training data contain historical bias. Sometimes here we can say that if a student, he has been passed in his examination, but he does not score a marks which is necessary to get a particular scholarship. Here data, it has not been updated by the institution or by that person himself. For what purpose? That he has given the examination for the betterment and he has scored the higher marks. But this betterment, higher marks, it has not been stored in the AI. Then in such cases, he may reject the scholarship form of the deserving candidate. So here we can say that if AI rejects the deserving student for scholarship because training data contains historical bias, new updated things was not provided to the AI. So here, who should be responsible? Whether the software developer, we can't say AI is the responsible because it is nothing but the one software. So whether software developer will be responsible, or the educational institution will be responsible, or we can say that government will be the responsible. Here, the question of accountability remains essential because AI is taking the decision only on the basis of data which has been collected. Technology itself is neither good
Madam,
or yes,
Madam,
ma'am? Yes.
after this slide, I think if it suits you, we'll take a short tea break
Yeah, sure, ma'am.
as per your convenience or and participants because we need a 10 minutes break in between.
Yes, we will take the 10 minutes break.
Okay. Please continue.
Yeah. Now, see, as I had told that technology itself, it is not good, even it is not the bad. Its impacts depends upon how responsibility it is designed, regulated, and used. As an educator, it is our responsibility to encourage innovations, but while ensuring that human dignity, privacy, constitutional values, it remains at the center of the technological progresses. We will take a break for 10 minutes, then we will continue. Is
Thank
it
you,
okay,
ma'am.
ma'am? Yeah.
All the participants, there is a 10-minute tea break. We will continue with the session after 10 minutes. So remain connected. Don't leave the session, be there, but there is a break. I think we should now resume the session again. Okay, madam.
Yes, ma'am.
Okay. Huh.
We see the Internet of Things and smart devices. As we have discussed how artificial intelligence relies on large amount of data. Now let us look at where much of that data comes from. Increasingly, it comes from the Internet of Things. Have you ever wondered how your smartphone counts your steps? How your smart TV recommends programs? How your voice assistants responds instantly to our questions? The answer is lies in the Internet of Things, a network of physical devices connected to the internet that continuously collect, process, and exchange data. The presentation lists several examples: smartwatches, then smart TVs, connected cars, smart homes, voice assistants. These devices make life earlier, but they also generate enormous amounts of personal data. Here, what type of information do smart devices collect? A smart watch collects heart rate, then sleep patterns, physical activity, trace level, GPS location. Smart TV records viewing habits, preferences of channels, time spent on the watching contents. Voice assistant may process voice commands, search history, household routines. Connected cars may record speed, routes traveled, driving behavior, then vehicle locations. Many users are unaware that these devices continue collecting information even when they are not actively using them. So there are some challenges. Continuous monitoring is there. Third-party data sharing. This all data, it can be shared with the multinational companies, with the advertisers, analytical firms, or business partners. Security, vulnerability. Poorly secure devices can become targeted by cyber attacks. A hacked smart home may expose personal routines and sensitive information. Lack of user awareness. Most users purchase smart devices for convenience, but very few carefully read privacy settings or understand data collection practices. Now, we will take one classroom example. Suppose a faculty member wears a smart watch that monitors health continuously. If this health information is leaked to an insurance company without consent, could it be affect future insurance policy? Definitely. So here, the privacy protection, it also necessary because it extend beyond traditional computer system. Now, we will see the next one, that is the social media and the data privacy. Today, billions of people use the social media every day. We are also using the social media platforms such as Facebook is there, Instagram, then Twitter, WhatsApp, YouTube, LinkedIn. How we are become the part of this, all these things has become the part of our daily life. Many users believe that these services are free. However, there is a famous saying displayed in this slide: if a service is free, are you the product? This statement encourages us things critically. These services are not free. Here, free for us, but it is giving so much benefit to the AI because it is collecting our several information and it is generally sells to the different types of companies, like advertisement companies there, then insurance companies there, health companies there. So what information do social media platform collects? They are collecting personal profile, contact list, location information, photographs, message database, interest, search history, shopping behavior, diverse information. Even when a message content is encrypted, metadata such as who communicates with whom and when can reveal significant behavioral information. So here behavior profiling, social media platform analyzes user behavior to understand interest, political preferences, consumer behavior, social relationship. So these enable personalized advertising, but also raises the privacy concern. Now there are some risks, that is the identity theft, data breaches, cyberbullying, misinformation, behavioral manipulation. These risk demonstrates why users should review privacy setting regularly. There is a study to understand the consequences of large-scale misuse of social media. Let us examine one of the world's most famous privacy scandal. The Cambridge Analytica data become one of the most significant example of personal data misuse in the digital age. According to this slide, here we will see what happened. Facebook user data was collected. Approximately 87 million users were affected. The information was used for political advertisement. Psychologically, profiling of voters was undertaken. This incident demonstrated that personal data could influence not only commercial decision but also democratic processes. Here, what went wrong? The primary problem was that user did not fully understand how their personal information would be used. Many individuals believed that they were participating in harmless online quizzes. Instead, their information and in many cases, information relating to their friends was analyzed for political campaign. So lessons which is to be identified, that lack of informed consent, misuse of personal data, importance of transparency, need for stronger regulations. These are the relevant things which is to be kept in the minds. Now we know that if there is, if we will consider some educational connections with this, universities also collect large amount of personal data, even colleges also collects a large amount of personal data. Therefore, this educational institution must avoid repeating mistakes seen in the commercial data collection. Now in the next case concern, different privacy challenges, not commercial profiling, but digital surveillance. Pegasus spyware controversy. This generated worldwide discussion regarding the surveillance and the privacy. Pegasus is capable of, this software, it is capable of spyware. It is capable of accessing calls, camera, microphone, messages, and location. Unlike ordinary malware, spyware operates secretly. The user may not even realize that monitoring is taking place. So the legal question arises, is it necessary for the national security? Whether individuals' privacy it was violated, is the judicial oversight and constitutional rights, whether it has been protected. So these questions illustrate the need to balance security and the liberty. In this, Supreme Court observed that privacy cannot be sacrificed without legal safeguards. Whenever there is a legal safeguards, then and then only we cannot claim the privacy. Now we'll see the deepfake and privacy. Artificial intelligence has made it possible to generate highly realistic fake contents. These creations are known as the deepfake. Now, what are the deepfakes? Fake videos, fake voices, fake images. Now, see here, already we are unlocking our phone. We have posted our photographs, so our images, deepfake images, it can be created. Now, if you see the videos, it can be created by way of these images. Now, how fake voices it is used, or from where they are collecting this data? Most of the times we are using the voice recognition software, voice speech recognition software. Here, why instead of typing a message, we are giving a voice command. So they are collecting our voices also. And because of these fake videos, it can be created. So what are the risks? There are risk of the theft identity. Person's identity may be misused without permission. Cyber frauders may intimate voices to obtain financial information. Sometimes we can get a call and we will think that it is the voice of our near and dear person, so we can help them according to his need. Financial fraud, it can be done. Defamation, false videos may damage an individual's reputation. Fake news, manipulated videos can spread misinformation rapidly. Then election manipulation, it can be done. Defect may influence public opinion during the election. Cyberbullying, students and young people may become victims of the digital manipulated images. Even for the sake of enjoying or for the sake of trying new this technology, what we are doing, we are using these different types of softwares and we are creating the fake videos. We can see that there are number of softwares on the websites or on the internet. If we are giving our particular images, they are making the videos of that particular images, but it is very risky. So the ethical question is, can AI destroy the trust? This is very important. Society depends upon the confidence that photographs, recording, and video represents reality. Defect challenges that confidence. Imagine if a fake video circulating online that falsely shows a teacher making inappropriate remarks. Even if later proven false, reputational damage may have already occurred. Therefore, legal awareness and digital literacy are becoming essential. So far as we have discussed privacy challenges in society generally, let us now focus specifically on higher educational institutions. Universities today function as major custodian of personal information. There are several categories of data routinely collected by educational institution. This includes admission records, examination result, health records, scholarship information, library uses, learning management system data, online class recording, research data. Each category requires appropriate safeguards. Why educational data is sensitive? Educational records reveals much more than academic performances. They may disclose financial background, medical conditions, attendance pattern, learning disabilities, personal contact details. Improper disclosure of this educational data can seriously affect the students. Now, if you will see that teacher, as a teacher, we must remind that we are the data custodian, and this data, it is belongs to the students. So educational institution, they must keep this data very securely. They must provide the protections. This means universities do not own the students' personal information. Rather, they hold it in the trust and must protect responsibility. Here, what best practices should teacher do? Only collection is not necessary. Whenever it is collected, it must store securely. Avoid sharing data on public platforms. Then avoid use unauthorized institutional systems and respect confidentiality at all. Now, we will see privacy challenges for the teachers. We have discussed the responsibilities of the educational institutions in protecting personal data. Now let us move from theory to practice and examine everyday privacy challenges that teachers encounter. Today, teachers are no longer just classroom instructor. We are also user of digital platforms, online assessment system, learning management system, cloud storage, video conferencing tools, artificial intelligence application, and social media. With these technologies comes with significant responsibility to protect student data. Here, we will see common privacy challenges. Uploading marks publicly. Sometimes teachers upload internal assessment marks or attendance records on publicly accessible link or notice board. Although done for convenience, such practices may violate student privacy. Instead of that, institutions should use secure portal where only the concerned student can access their records. Second one is privacy challenge for the teacher, sharing students' phone number. It is the common problem everywhere. We are having the WhatsApp group of students. By adding students directly, this reveals students' personal phone numbers to all members. A better approach is to seek consent before adding the student and use institutional communication platforms where possible. Then using personal WhatsApp groups. Personal messaging applications are convenient but may not be appropriate for handling sensitive academic information. Confidential discussions regarding disciplinary proceedings, counseling, or examination matters should be conducted through authorized institution channel only. It should not be shared on the WhatsApp groups. Regarding online lectures has become common. However, recording often captures students' images, voices, and personal surroundings. Teachers should inform students before recording and clarify how recording will be used and for what purpose it will be used. Cloud storage. Many faculty members store examination papers, research data, and students' record in personal cloud accounts. Sensitive institutional information should be stored only on secure authorized system with appropriate access control. Next one is the artificial intelligence tool. Increasingly, teachers uses AI tool for preparing lectures, evaluating assignment, or generating the educational contents. Before uploading students' assignment or research data to AI system, teachers should consider whether personal information is being shared and whether institutional policy permits such use. Next one is the biometric attendance. Biometric system collects fingerprints or facial recognition data. Such data is highly sensitive and requires stronger safeguards than ordinary personal information. Institution may ensure that biometric information is collected, and this biometric information, when it has been collected, this information is collected lawfully, stored securely, and accessed only by authorized personnel. Best practice is collect only the minimum and necessary data. This is known as the data minimization. The less personal information we collect, the lower the privacy risk. Now we will turn towards the constitutional responsibility of the teacher. We must respect the human dignity, then protect student privacy, promote the digital ethics, encourage responsible technological use, and foster constitutional values. There are some fundamental duties which need to be followed by all teachers. Let's see. Best practices for protecting the privacy. Now here, there are privacy issues, which is very burning, and privacy protection, it is the everyone's responsibility. So here, we will see the individual and educational institutions practices for protecting the privacy. Best practices for individual, strong password, it should be unique, then significantly complex, avoid using birth date, the names or simple numerical combination. If you multi-factor authentication must be there, even if a password is comprised, multi-factor authentication provides an additional layer of protection. Means when we will sign in a particular email address at that time, here not only the password, in multi-factor authentication we can have the two-way protection system. We can also ask for the OTP in our mobile, or we can have any other one more mode for protecting the privacy. Then privacy setting, Users should regularly review privacy setting on social media, email accounts, cloud storage, mobile applications. We should always do the software updates. So here, many cyber attacks exploit the updated softwares. Avoid public Wi-Fi. This is the sensitive activity such as online banking or examination related work should not be conducted using unsecure public networks. There are so many chances of the hacking or the cyber fraud. So we always should avoid the public Wi-Fi. What are the best practices for educational institution for protecting the privacy? Here, privacy policy, every institution should adopt the clear privacy policy explaining what information is collected, why it is collected, how it will be used, how long it will be retained. Then data minimization, collect only information that is genuinely necessary. Access control, only authorized person should have access sensitive records. Each and every person who is working in the institution, he should not get the access to such type of records. Regular security audits, periodic review helps identify vulnerabilities before problems occurs. Then cyber awareness training, technology changes rapidly, so continuous training ensures that teachers and staff remain aware of the emerging risks. That's why here cyber awareness training, it must also be given. So here we have seen the privacy is the fundamental right, data it is the valuable asset, technology must respect the human dignity, ethics and law must work together, teachers are custodian of the student data, responsible AI requires the responsible citizen. So with this, I will say that privacy is not a simple legal concept or the technological, it is or a technological issue. It is the reflection of how much we value human dignity, autonomy, and the trust. As a teacher, we influence not only what students learn, but also how they behave in a digital world. By protecting personal data, using technology responsibly, and promoting constitutional values, we help create a safer, more ethical, and more democratic digital society. If you have any questions, you can ask. So we will turn towards the second topic of our session, that is data privacy law, artificial intelligence, and institutional responsibilities. Any questions on this, or shall I turn towards the next topic? Yes, anyone want to ask? Shall I move toward the next? Am I audible?
मैम मेरा क्वेश्चन है कि जैसे हम लोग मोबाइल में हेलो
यस
लोकेशन मैम अगर ऑन रहती है तो ये रिस्की हो सकता है क्या?
Yeah, definitely. Whenever it is required, that time only we should have the on our location. Otherwise, it would be risky.
Okay, thank you, ma'am.
Shall I go for the next topic?
Yeah, sure, ma'am.
Yeah.
Yes, ma'am.
Is it visible?
Yes, ma'am.
Okay. Proceed. The topic which we will cover is data privacy law, artificial intelligence, and institutional responsibilities. Now we know that in our first session, we have explored the concept of privacy as a constitutional value. We discussed how privacy is connected with the human dignity, liberty. Now, generally, in this session, we will move one step further. from constitutional philosophy to legal implications and institutional responsibility. So we will see in today's session. It will design to help us to understand legal framework that governs the personal data in India. Now see, this before moving towards, let us have one glance on the privacy. As we know that privacy is nothing but the personal data, sensitive data, and who can control this data. So here, when we are saying that who can control this data and how it can be controlled, who data is belongs to whom, all these aspects, it will be generally seen in the Digital Privacy Data Protection Act. So here, this Digital Privacy Data Protection Act, it has been enacted by the Parliament in 2023. Then artificial intelligence data governance is there, institutional responsibilities, best practices for educational institution. All these things we have seen. Now we'll see why India needed a data protection law. India has witnessed remarkable digital transformation during the last decade. Now, let us think about dramatically our daily lives have changed. Today we use Digital India services, then UPI payment, internet banking, digital health records, online education, cloud computing, artificial intelligence, even nearly every activity now lives behind the digital record, digital footprints. Every payment, online class, every online meeting, every mobile application, hospital visit, railway booking, social media post, all these are generally a digital data creators. This digital transformation has generated tremendous opportunity. So there are emerging risks which we have seen. There are the identity theft, financial fraud, data breaches, cyber crimes, then mass surveillance, unauthorized profiling. So here, why it need to be protected? Here, we know that these two things are equally important: protect the citizen and enable the digital economy. Notice that law seeks balance, not opposition. India does not wish to stop innovation. Instead, objective is to ensure that technological process respect constitutional values and individual rights. Suppose a university introduces an AI-based learning platform, students may benefit from personalized education. However, question is again, what type of information is collected, who has the access, how long it will be covered. So all these questions, it will demonstrate why legal regulation is necessary. Now, we will see evolution of India's data privacy framework, or how India's data privacy it has been protected. In 2000, Indian government have passed the Information Technology Act, which provided India's first comprehensive legal framework for electronic records and cyber related issues. Although privacy was not its primary objective, it created the foundation for regulatory digital transaction. Here, number of cyber crimes, it has been generally penalized. Then in 2011, sensitive personal data rules, it came into existence. As digital information increases, additional rules addresses the handling of sensitive personal information. These rules recognizes that certain categories of data requires greater protection. Then we have already seen the Swami's case judgment where the right to privacy it was recognized as the fundamental right. Then the 2018 Justice B.N. Sri Krishna Committee report, it recognizes the need for comprehensive legislation, and expert committee examined international development and recommended a dedicated data protection law. This report significantly influenced later legislative development. So in 2023, the enactment of Digital Personal Data Protection Act, it came, and it reflects the country's efforts to balance innovation with privacy protection. Law is dynamic, it continues evolves to respond to social and technological change. Just answer the one question. Do you think technology develops faster than the law? Yes, anyone? Do the technology develops faster than the law? The answer is definitely. Here, technology is developing faster than the law. And
Yes,
that's
yes,
why,
ma'am.
yes, and this technology is developing faster than the law. That's why whatever laws we are making, sometimes it has some loopholes. That's why here, after the Information Technology Act, it was not covering the protection of the privacy as well as the protection of the data. That's why in 2023 we enacted the Digital Personal Data Act. Now we will see what are the objective of Digital Personal Data Protection Act. Here, it protects digital personal data. The first objective is very straightforward. Individuals should enjoy legal protection. Then when organization is collecting, store, using, or sharing their digital personal information, respect individuals' rights. People should retain meaningful control over their own information. Privacy strengthen autonomy and dignity. Then ensures accountability. Organizations handling the personal information of the students or of any person must act responsibilities. Then educational institutions like colleges, university, hospital, businesses, and government departments should all follow lawful procedures. Then promote responsible innovation. The law does not discourage artificial intelligence or digital development. Instead, it encourages innovation that respect individuals' rights. Facilitate digital governance. Government increasingly provide digital public services. Effective governance requires appropriate data management and next objective is balance privacy and development. This is the most important objective. Economic development and privacy are not enemies. Balance the both. Here, there is a one principle: lawful, fair, and transparent processing. Whenever organization processes personal information, they should ask themselves three questions. Is it lawful for collecting the personal information? Is it fair? And is it transparent? If answer is no, then organization should not move towards for collecting the personal information. Now, for example, suppose a university collects students' mobile number to communicate examination schedule. Later, those numbers are used for commercial advertising without informing students. Would that be fair and transparent? Definitely not. Here, if it has been collected only to communicate the examination schedule, then only for that purpose, this mobile number must be restricted. It should not be given to any companies who are doing the commercial advertisement. Now see scope of the DPDP Act. Here, understanding the scope of legislation. Here we will see this act applies to digital personal data, then online collections. Online collection is nothing but online admission forms, students portal, university website, mobile applications. Then offline data, later digitalized. Sometimes information is initially collected on paper but later converted into digital records. You know that most of the data it has been digitalized, which were offline. So here this online data later digitalized, it is applicable to that also. Government bodies, government department handling their personal information are included within the ambit of this act. Private organization like business companies, private institutions handling digital data are also covered under this act. Educational institutions are also covered under this act. In universities, colleges collect number of personal data, and that's why it has been also included. So here, situation outside the scope, what generally is not collected. Here, to general exclusion, personal or domestic use. Certain purely personal or domestic activities are outside the act scopes. Certain legal exempt processing. So here we will see some practical example. Imagine a college introducing an online alumni portal. Institution should consider what information is necessary for alumni portal, why it is being collected, who will access it, how long it will retain, and what security measures are placed to secure this data. Now, there are most important definition which is related with this act is data principal, data fiduciary, data processor, and personal data. So, first definition is the data principal. The first and most important is data principal. It means individual to whom the personal data relates. Example, we will discuss example afterwards, but see here, the data principal, it is nothing but the individual to whom personal data is related. Data fiduciary is the next important concept. Data fiduciary is a person or organization deciding the purpose and means of processing personal data. Now tell me, in case of the educational institution and a student, who is the data principal and who is the data fiduciary? Data principal means the individual to whom personal data relates, and data fiduciary means the person or the organization who are generally processing the data, who collects the data. Whether student is data fiduciary or the data principal. And what about the
Data principal.
Student is
Data principal.
Data principal, definitely, because the data is belonging to that particular student, and data fiduciary will be the institutions who are collecting the data. Now we will see the data processor. Data processor, unlike the data processor does not decide the purpose of processing. For what purpose the data it has been collected, it will be decided by the fiduciary. Instead of processes information on behalf of the data fiduciary. Here, data processor will not decide for what purpose we are collecting the data. They are only acting on behalf of the data fiduciary. Now, for example, as I have told that student, here data principal will be the student whose admission form is stored, then teacher whose salary records are maintained, patient whose hospital records are digitalized, and the citizen who linked Aadhaar information. So all these will be the data principal. Now, in the example of data fiduciary, you can say that universities, school, colleges, hospitals, bank, companies, government department, all it will be the data fiduciary. Now, as I had told that data processor is not collecting the data, he is not deciding for what purpose data is collected. He is only processing or he is acting on behalf of the data fiduciary. So here we can say that data fiduciary will be a company who processes the information. We can take the example. Suppose university appoints an external company to manage its online examination portal, then that company will be a data processor. Or here we can say that MKCL, generally MKCL will be the data processor and data fiduciary will be the university. So software company will be the data processor. Then personal data, this is the most important definition. As already we have seen, what do you mean by the data? It includes name, mobile number, email address, photographs, then Aadhaar number, student's ID, examination records, biometric information, even IP address of the devices. It will also include the data. Now, we will see some key principles of data protection. Here, lawful processing. Every organization must process data according to the law only. No institution can collect information simply because it wants to. There, always must be lawful basis. Purpose limitation. Data should be collected only for specified and explicit purposes. For example, suppose a college collects students' mobile number, examination notification. Later, those numbers are used for commercial marketing. Then definitely it would not be acceptable. Data minimization. Here, whatever data is collected, that collected must be only the necessary data. Unnecessary data should not be collected. Then accuracy and security. Inaccuracy, incorrect information may seriously affect individuals. Suppose examination marks are entered incorrectly, consequences would be severe. Therefore, accuracy is more important while maintaining or handling the data. Therefore, institution may regularly verify data accuracy. Then security, information should remain protected through encryption, password, firewall, security, servers, access controls. So security supports the privacy. Now, example, imagine a college storing students' record on a personal laptop without password protection. Even if no misuse occurs, this is a poor data governance. Now we will see the consent under Digital Personal Data Protection. Consent lies at the heart of the modern data protection. However, every data consent is legally valid. Consent must be free. It must, there shall not be no caution, no any pressure shall be there. It must be specific for what purpose the consent it has been given. It must be identified. It must be informed. Individual should understand why information is collected, why it is received. Now tell me, are we taking the consent from the student before collecting the data? Are we taking the consent from the student while collecting the data? Yes, anyone can answer it?
No.
No. So here consent is very important. We shall take it. Then next one is the we were dealing with the informed. Individuals should understood what information is collected, why it is collected, who will receive, and how long it will be retained. All these things are very unconditional services should not impose unnecessary conditions unrelated to the state's purpose. Then unambiguous consent should be clear affirmative action must be there. So here what individuals should know in the consent, for what purpose data is collected, why it is collected, how long it will be used, and how long it will be stored. Now here, as I have told you, the consent. Now see, if we see the consent, if any app it has been here, one video I have played. In video, it has been shown that the location and phone permissions are required whenever we are using one particular app. At that time, if permission it has not been given, then the particular app it will not work. So here, see here, this video shows that the app needs the turn on location and phone permission. Now see here, if we are using a Ola app or any app which is providing the services of transport, at that time, what do you think, which permission is required? ट्रान्सपोर्टेशनचा ऍप वापरत आहोत आपण, त्यावेळेस कोणती परमिशन फक्त दिली पाहिजे, कोणती गरजेची आहे? आपले कॉन्टॅक्ट्स गरजेचे आहेत? येस,
नाही.
लोकेशन, राईट? आपल्याला कुठून कुठे जायचं आहे, बट हियर the app is not working. Why? Location and phone permissions are not given. Now see here how gates works. Now see here, we have seen that unless and until a permission it has not been given, the app it will not work. But here we have told that permission must be with consent. But here forcefully permission it has been generally taken. So we can say that even permission it need to be taken. It has been said by this DPDP Act, but there is no any choice it has been given to us unless and until we will give the permission. This app it will not work. So we can say that it is one of the loophole. Now we'll see rights of the data principle. Right to information, why the data, personal data it has been used, how it for what purpose it has been collected, then when it will be erased. Even we have the right to erase. We can make the request to the data fiduciary that my whatever data it has been collected, please erase it. Then grievance redress it has been given. Suppose if privacy policy it has been ignored, then in such cases we can have the grievance procedure also. Then nominate another person. Here, if we want that on behalf of us, another person should exercise our rights on our data, then also this particular provision it has been given. So why these rights matter? They give individual greater control over their personal information and promote transparency and accountability. That's why all these rights of the data principles are necessary. Now we will see the rights of the data fiduciary. If individual possesses rights, organization must have corresponding responsibility. This act imposes several obligations on the data fiduciary. We have seen that data fiduciary, it means the person or organization who are collecting the data, university, hospitals, etc. So here, first responsibility is process data lawfully. Whenever law is giving permission, every activity should comply with the law. Obtain valid consent. Processing should occur according to the applicable requirement. Then ensure data accuracy. Whatever incorrect information is there, it should be corrected promptly. Provide responsible security safeguards. Then notify data breaches. If data breaches occurs, then we should inform the individual which your data it has been breaches. Delete data when no longer required. Unnecessary retention increases the privacy risk. That's why the data it shall be deleted when it has not been required. Establish grievance mechanism. Individuals should know where to submit the complaints. So, for example, in a educational institution, there must be some mechanism. If our data it has been violated, then where to complain. All these mechanism it should be provided. Now we will see the next one is that rights and duties. These are the balance approach. Whenever we are saying that we are claiming the rights, we must fulfill our duties. Modern privacy law is built upon the balance. Rights alone are insufficient. Responsibility are equally important. Now we will see the rights of the individuals. Right to information, right to collection, right to erosion, right to grievance redressal, right to nominate. These are the rights which empowers the citizen. Now we will see which are the duties of the individual. Avoid providing false information, avoid impersonation, respect others' privacy, use digital responsibility, responsible digital citizenship. Every online action has consequences. For example, Forwarding someone's confidential photograph without permission violates both ethics as well as the privacy. Creating fake accounts amounts to impersonation. Digital freedom therefore requires digital responsibility. Digital rights come with the digital responsibility. Now there is a children's data and it need to be protected under the DPDP Act. Why does the law give special protection to the children? As we know that children's, they are generally using the technology. They use online learning platform, educational apps, social media, then gaming platforms, AI-based learning tools, and they cannot know how to protect their privacy, what information it is to be uploaded. However, children usually cannot fully appreciate long-term consequences of sharing personal information, then online tracking. That's why here special protection it has been given to the children. Verifiable parental consent it is given. Then additional obligation, that is educational institution and digital services provider may have additional responsibility whenever schools are taking the or collecting the data of the children. The parents consent it must be taken. Protection from harmful processing. Here children's personal information should never be processed in ways they may harm their well-being. For example, suppose a school introduces an AI-based learning application that collects students' photographs, video, recording learning behavior. Then in such cases, unless and until they are taking the parents' consent, they should not collect all this information. Now see the data breach. Data breach, it is nothing but the unauthorized access, disclosure, loss, theft, alteration, or destruction of the personal data. Notice that hacking is only one form of data breach. There are many breaches occurs because of simply human mistake. Now example, university database, it can be hacked. So many cyber criminals gain access to confidential student information. Lost of laptop, it also get the here we can say that it is also the data breaches, because data hacking it can be done. Wrongful email recipients, here also there is a data breach. Cloud storage exposure. Why are data breaches serious? Because consequences are including identity theft, financial fraud, then emotional distress, legal liabilities. So that's why data breaches are very serious. And here, whenever data breaches are there, it is necessary that complaint it must be done. Now we'll see the security safeguards. Every privacy cannot be exist without security. Here, what type of security, how it can be generally made on the data. Here, encrypt sensitive data. Encryption converts readable information include coded information. Even if data is stolen, encrypted reduces the possibility of misuse. Then use multi-factor authentication. Passwords are alone no longer sufficient. Additional verification methods such as OTP or authentication applications, it provides stronger protection. Then install firewalls also, secure cloud storage, maintain backups, update software, train employees, then privacy by design. This means privacy should be built into system from the very beginning, not added after later problem arises. So here, these are the securities which need to be security safeguard which need to be followed by each and every person. Now, if data it has been breached, then here what remedy is available? Data Protection Board of India, it establishes by the DPDP Act. Here it functions. One is these Data Protection Board, it receives the complaint from individual regarding privacy related issue. Then second function is that they investigate violations where organization failed to comply with legal obligations. They direct remedial measures to correct identified problems. Then they imposes penalty where provided by the law. The purpose is not merely punishment. The object is to improve compliance. It encourages organizations to follow responsible data governance. Now, why this board is important? A law without enforcement becomes ineffective. This board helps ensure accountability, transparency, compliance, public confidentiality. Suppose educational institution repeatedly ignores privacy complaint. Mechanisms such as data protection boards strengthen accountability under the legal frameworks. That's why Digital Protection Board of India, it is very important. Now see, AI and data privacy. We have already seen this aspect. Here, AI can learn, predict, analyze, personalize, and make decisions. And AI applications like health, education, banking, agriculture, justice, governance. These are the many applications. They improve the efficiency. And if you see the benefits, it has greater efficiency. AI improved accuracy. They are better decision making. Now we can say that in educational institution, we can take the example university increasingly use of AI, student counseling, learning analytics, then examination supports, library recommendation, academic planning. AI helps identify students who may require additional academic assistance. Now, we'll see some privacy risk of artificial intelligence, mass surveillance. AI enables continuous monitoring of individuals through cameras, sensors, and digital platforms. Excessive surveillance may affect the personal liberty. Then profiling. AI enables behavior to predict preferences, purchasing habits, then learning styles, and even future actions. Such profiling may influence important decision. Algorithmic bias. AI system learn from the historical data. Sometimes here, whatever historical data, if it has not been updated, then definitely if training data contains bias, AI may produce the unfair result. Facial recognition. Facial recognition technology provides convenience. However, it also raises questions regarding consent, continuous monitoring, misidentification, data storage, then defects. We know that realistic fake videos, voices, and images, it can be created. This technology creates serious concern regarding identity, reputation, and misinformation. Then behavioral prediction. It predicts the consumer behavior, academic performance, ethical. We will see the ethical consent, transparency, fairness, accountability, and human oversight. All these are the ethical principle, and it should guide responsible AI governance. We can say that artificial intelligence ever become completely fair? Definitely not. Artificial intelligence remains subject to human values, constitutional principles, and legal safeguards. Artificial intelligence in a higher education, it is the most important. Now we know that university, they are using the AI learning management system. Modern learning management system platforms analyze students' learning behavior. They can identify students who are falling behind, frequently access study materials, learning patterns, attendance trends. This helps teacher provide timely academic support. Then online examination, AI assist universities in conducting secure online examination. It helps monitoring examination integrity and detect suspicious behavior. However, AI should support, not replace human supervision. AI tutor. AI-powered tutoring system provide personalized explanation, instant feedback, practical questions, revision support. Student can learn at their own pace with the AI tutor. But remember that AI tutor never can replace the teacher or the professor. Then learning analytics, AI analyzes academic performances to predict which students may require additional mentoring. Early intervention can reduce dropout rates and improve learning outcomes. Plagiarism detection, we all know about this. AI-based plagiarism tool assists teacher in identifying copied academic work. This tool promote academic honesty while reducing the manual efforts. Student performance prediction, AI can analyze attendance, assignment submissions, assignment patterns to identify students who may need academic counseling. We'll see some benefits. There are two major advantages: personalized learning, administrative efficiency. Routine administrative works become faster, allowing teachers to devote more time to mentoring and research. Now, there are some challenges. That is privacy, bias, transparency, data security. These challenges requires careful governance. Now we will see some cyber security and data privacy. Now here there are some common cyber threats: phishing attacks, then malware, ransom, identity theft, password theft is there. Then email spoofing, hacking, cloud data breaches, mobile app vulnerability. Now see here, all these are the data, all these are the generally threats, cyber threats, and these cyber threats, they are breaching the data privacy. So here we can say that there must be protected, and cyber security, it must be generally increased. Unless and until cyber security it has not been increased, then data, it will not be privatized. Here we can say that no without cyber security. So cyber security, it must be seen by each and every institution. Cyber security, it protects the data privacy. Now see, cyber security, it protects how data privacy. Phishing attacks, it is deceptive emails to steal credential. Always verify emails before opening the links or attachment. Never share password through emails. Then malwares and ransomware. Here, these are the malicious software locking or stealing data. Install trusted antivirus software. So avoid downloading files from unknown websites. Password theft, it is a brute force and credential surfing. Use strong password, multi-factor authenticity password managers where appropriate. Never reuse the same password across multiple services. Cloud data breaches, it is unauthorized access to stored data. Only use secure, authorized, and sensitive data should never be stored in unsecured personal account. And mobile app vulnerabilities, it is an insecure apps exposing personal data. Before installing an app, ask, does it really need access to my contacts? Why does it require location? Why does it require microphone access? Review permissions carefully. We'll see best cyber security practices for the teachers. Strong password and multi-factor authentication. Long, unique, difficult to guess such type of password must be kept. Then we must enable multi-factor authentication. Software updates, it is the best cyber security practices for everyone, not for the teachers. We should update the software regularly. Regular software update, fix known security vulnerabilities. Never postpone important security updates unnecessary. Avoid public Wi-Fi. Encrypt confidential file. Verify emails from devices like mobile, tablet, phones. Backup every academic data. Regular backup protects against hardware failure, ransomware attacks, accidental deletion. We will see one golden rule, that is think before you click. Most cyber attacks succeeds because someone clicked a malicious link. One careless link can expose an entire institution. So before clicking, we must think twice. Is it really necessary or not? Now, here we'll see the General Data Protection Rule, which has been enforced in 2018, and India has enabled the Digital Personal Data Protection Act in 2023. The scope of these general data protection rules, it covers broadly all the personal data. It indicates the all personal data, it should be covered here. They also ask for the consent. This general data protection rule places a strong emphasis on consent. It requires notice and valid consent within its framework. Both, if you will see, both laws, generally this framework recognizes rights relating to personal information through their legal structures, and common objective is to strengthen the individual control over the personal data. Now we will see the institutional compliance checklist. Privacy policy and data classification. Every institution should have a clear written privacy policy explaining what personal data is collected, for what purpose it is collected, who can access it, how long it will be retained, when it will be deleted. Data should also be classified according to its sensitivity, such as public information, internal information, confidential information, then highly sensitive personal information. Restrict access and train staff. Not every employee need access to all institution data. Access should be based on role and necessity. For example, examination staff should access examination record, financial staff should access free records, libraries staff should access the library information. Regular training should be organized for faculty and non-teaching staff whenever necessary. Due to this, they will know how to deal with all these things. Then there is a consent and breach reporting. Now see here, obtain the valid consent. As I have told that generally we are not obtaining the valid consent of the student, but it is the need of the time, as data is act is also saying that we must obtain the valid consent, and that's why here valid consent must be obtained whenever there is a breach of the data. So institution should give the information regarding the breaches. Ignoring or hiding a data breach can worsen its consequences. If here there is a breach, then in such cases we can make the complaint to the data protection board also. Then delete and audit. Delete unnecessary data, review data retention practices, conduct the privacy security audits. Here, privacy by design and not by default. Privacy should be built into institutional system from the beginning, not added only after problem occurs. We'll see faculty guidelines for responsible data handlings. Teachers are amongst the most important custodian of students' information. So this slide presents practical guidance on what faculty should do and should avoid. Do here what the teacher should do: maintain confidentiality. Students' record, examination result, counseling notes, research data should remain confidential. Never discuss confidential student matters in public places. Then use secure institutional platforms. Always use authorized institutional email, learning management system, and official data, official cloud storage for academic purpose. Protect research participant. Researcher must obtain informed consent. Protect participant confidentiality. Then store research data. What teachers should not do: don't share students' record publicly. Never upload mark sheet, attendance record, internal assessment, personal data collection to publicly accessible platforms. Don't use unauthorized AI tool. Avoid uploading confidential student assignment, examination paper, or research data to AI tools unless permitted by the institutional policy. Don't share sensitive data or unsecured devices on unsecured devices. Personal laptops or USB drives without adequate protection create unnecessary risks. Don't forward confidential emails. Always verify that recipient is authorized before forwarding the confidential information. Here we will take one practical example. Suppose a teacher accidentally sends internal assessment marks to a wrong students group. Even if unintentional, it may amount to the privacy breach. Here, key message is that good privacy practices begin with everyday professional behavior. We'll see the emerging technologies and privacies, Internet of Things and drones, Internet of Things devices such as smart watches, cameras, sensors, and wearable devices continuously collect our data. Drones may capture personal information in public places. Question arises, who owns this data, who controls it, how long it will be stored. Then metaverse and brain-computer interface. Immersive digital environments may collect behavioral information, voice data, eye movement, activity. This technology creates unprecedented privacy challenges. Blockchains, it offers secured and tampered resistance record. However, because records are difficult to erase, question arises regarding the right to eraser under the data protection law. Then quantum computing, it has a potential to break many current encryption methods. Future privacy protection will require stronger cryptographic standards. Here, future challenges will come to an end. Future challenges in data privacy. Digital world presents several ongoing challenges that will shape and future privacy law. AI deepfake, AI generated videos, voices, images can manipulate public opinion and damage reputation. Deepfake challenges trust and identity verification. Mass surveillance, government corporates increasingly possesses technological capable of monitoring large population. The challenges is balancing national security, public safety, and individual privacy, cross-border data transfer. Digital information often travels across multiple countries. Different legal systems create enforcement difficulty. International cooperation therefore becomes increasingly important. Last one is the innovation versus regulation. Perhaps the greatest challenge is maintaining balance. Too much regulation may discourage innovation. Too little regulation may undermine the privacy and fundamental rights. So there must be the balance between these two. Now, here we will see, before concluding, let us summarize today's most important lessons. Privacy is a fundamental right which has been guaranteed under Article 21 of our Indian Constitution. Ethical, stringent legal compliances. Compliance is not merely about avoiding penalties. Ethics encourages possible behavior even where the law is silent. Then transparent AI system should remain transparent, accountable, fair, and subject to human oversight. Educational institutions are the custodians. University holds personal information in trust. They should not own students' data. Cybersecurity, privacy cannot exist without strong cybersecurity. Responsible digital behavior, every citizen has the responsibility to protect personal information and respect the privacy of others. Now see here, with the end of the discussion, here we can say that privacy, ethics, and technology. If all these has been summarized, then and then only responsible digital society it can be created. So here, should government, we can ask the questions to ourselves, is complete privacy possible in the AI era? Definitely, complete privacy cannot be possible, but whenever there is a violation of privacy, here we should go for the remedy, but it must be controlled. That violation of privacy, it must not be there. Then should government regulate AI more strictly? Definitely it should be regulate more strictly, but it should not discourage the innovation. How can teachers promote digital citizenship? Definitely we can we can create the awareness, and for the digital citizenship, here we must teach our student also how to be safe and what type of data it should be protected. We should not interfere into the another's private data. And last one, what should universities do to build culture of privacy? Here, for protecting the privacy, culture of privacy, university must have their own rules and regulation, including the cyber security, as well as if data breaches occurs, then university should provide the remedy for this also. So here, I would like to express my sincere thanks to the UGC Malviya Mission Teacher Training Center, Dr. Babasaheb Ambedkar Marathwada University, Chhatrapati Sambhaji Nagar, and to Dr. Nandita Patil Madam, the coordinator of this STC, for providing this opportunity to engage with such an important and contemporary subject. Thanks once again. I'm happy to answer your questions. If you're some questions, I'm ready to answer it. Any questions?
Are there any questions, or we should conclude with the session?
If questions are there, questions are welcome.
I think we should now
Yeah.
go ahead with the
मैम
vote of thanks.
इसका अगर पीडीएफ अवेलेबल हो जाए तो बहुत अच्छा रहेगा मैम, या वीडियो
Yes.
लिंक.
I will share with the madam. Madam will give you.
Thank you, ma'am. Thank you.
Okay. Now I request roll number 38 to express vote of thanks to our today's resource person, Dr.
Yes,
Shilparani
ma'am.
Dongre. Thank you.
धन्यवाद मॅडम. डॉक्टर बाबासाहेब आंबेडकर मराठवाडा युनिव्हर्सिटी UGC मानवीय मिशन टीचर ट्रेनिंग सेंटर छत्रपति संभाजीनगर आयोजित STC इन प्रोफेशनल एथिक्स यूनिवर्सल ह्यूमन वैल्यूज अँड कॉन्स्टिट्यूशनल रिस्पॉन्सिबिलिटीज या कोर्स अंतर्गत आज पहिले 2 सेशन मध्ये डॉक्टर शिल्पाराणी डोंगरे यांनी अतिशय माहितीपूर्ण असे आपले लेक्चर्स दिलेले आहेत. डेटा प्रायव्हसी या विषयावरती त्यांनी आपले अतिशय चांगल्या रीतीने मांडणी केलेली आहे. त्यामध्ये मिनिंग ऑफ प्रायव्हसी अँड की कन्सेप्ट, कॉन्स्टिट्यूशनल फंडामेंट, फाउंडेशन्स, त्यानंतर लँडमार्क जजमेंट्स, ह्युमन राईट्स पर्स्पेक्टिव्ह, प्रोफेशनल इथिक्स, AI and emergency challenges, privacy in higher education and role of the teachers आणि डिजिटल चॅलेंजेस. तर ह्या विविध ऍस्पेक्टच्या माध्यमातून मॅडमने अतिशय चांगल्या रीतीने मार्गदर्शन केलेलं आहे. त्याच्यामध्ये आपला डेटा, त्यानंतर कन्सेप्ट ऑफ डेटा, त्यानंतर आपल्या माहितीचा कसा इतरांकडून गैरवापर होऊ शकतो याविषयी त्याने अतिशय सखोल माहिती दिली. त्यानंतर डेटा म्हणजे काय, डेटाचे प्रमुख प्रकार कोणते आहेत, म्हणजे तो आपण कसा सुरक्षित ठेवला पाहिजे. त्यानंतर AI आपण वापरलेल्या डेटाचं कसं विश्लेषण करत असतो आणि तो आपल्या जाहिरात कंपन्यांना कसं पुरवतो. त्यानंतर प्रायव्हसी संदर्भातल्या घटनात्मक तरतुदी आपल्या राज्यघटनेतील कलम 14, कलम 19, कलम 21 मधल्या तरतुदी आणि आपल्या डेटा प्रायव्हसी यांच्या संदर्भातलं सखोल माहिती त्यांनी दिली. त्यानंतर विविध न्यायालयीन निर्णयांचा सुद्धा त्यांनी संदर्भ या ठिकाणी दिला आणि डेटा प्रायव्हसी मानवी मूल्यांशी कशी निगडीत आहे याची माहिती दिली. उच्च शिक्षण आणि डेटा प्रायव्हसी या संदर्भातही मॅडमने मार्गदर्शन केलं. दुसऱ्या भागामध्ये मॅडमने डेटा प्रायव्हसी लॉज, आर्टिफिशियल इंटेलिजन्स अँड इन्स्टिट्यूशनल रिस्पॉन्सिबिलिटी. तर ह्या लेक्चरमध्ये मॅडमने DPTP ऍक्ट 2023 मधील विविध तरतुदींचा सविस्तरपणे आढावा घेतला आहे. त्यानंतर आपल्या राईट्स आणि ड्युटीज या संदर्भातही त्यांनी माहिती दिली. लहान मुलांना असलेले कायद्याचे संरक्षण, डेटा हॅक किंवा ब्रीच कसा केला जातो आणि डेटा प्रोटेक्शन बोर्ड ऑफ इंडियाची कार्य काय आहे. त्यानंतर AI आणि डेटा प्रायव्हसी, AI आणि प्रायव्हसी रिस्क, AI आणि हायर एज्युकेशन, ते त्या वापरत असताना त्याचे फायदे तोटे, सायबर सुरक्षितता आणि डेटा प्रायव्हसीचे प्रकार, सायबर सिक्युरिटी प्रोटेक्ट प्रायव्हसी, सायबर सिक्युरिटीसाठी घ्यावयाची दक्षता, त्याची चेकलिस्ट, फॅकल्टी गाईडलाईन्स फॉर रिस्पॉन्सिबल डाटा हँडलिंग. तर या संदर्भात मॅडमने अतिशय सविस्तर असं आम्हाला मार्गदर्शन केलेलं आहे. त्याबद्दल मी त्यांचं व्यक्तिशः आणि MMTC कडूनही त्यांचं आभार व्यक्त करतो. संयोजकांनी मला आभार मानण्याची संधी दिली त्याबद्दल मीही त्यांचं आभार मानतो. धन्यवाद.
थँक्यू सर. थँक्यू मॅडम.
ओके मॅम.
थँक्यू मॅम.
Thank you. Thank you, everyone.
Thank you, madam.
Yeah, we will now meet in the afternoon session, which will start at 3 o'clock.
Okay.
Madam, thank you for the insightful session. Thank you.